Most retirees never imagine that the single riskiest thing in their entire financial life is sitting quietly at their local bank, printed right there on a checking account they have used for 30 years. But it is, and every year thousands of older Americans lose money they can never get back, not to a scammer, not to a stock market crash, but to a name they added to their own bank account with the best of intentions. Some lose a few $1,000s, others lose their house. One woman you are about to meet came within a single signature of losing more than $200,000, and she had no idea the danger even existed until it was almost too late. If you have added someone to your account or you are thinking about it, the next few minutes could be the most valuable minutes you spend all year. Welcome to Retirement Guide, the channel where we sit down together and untangle the confusing and honestly sometimes unfair rules that shape retirement in America so you can protect the money you worked your whole life to build. If you find this helpful, take a quick second to subscribe. That is all it takes to make sure these updates keep finding you, because the rules keep changing and nobody at the bank is going to call you when they do. Now, let me introduce you to three people, three real kinds of situations, because their stories are going to teach you almost everything you need to know. Our first friend is Rosemary. She is 69 years old, a widowed former librarian living in a small town in Vermont. Rosemary is careful. She clips coupons, she pays her bills the day they arrive, she has never once bounced a check in her life. But careful is not the same as informed, and Rosemary made a decision that felt loving and simple, the kind of decision millions of parents make, and it opened a door she never even knew was there. We will get to what happened to her, and it is going to surprise you. Our second friend is Curtis. He is 63, a retired civil engineer from Arizona. Curtis is sharp. He spent 40 years reading blueprints and catching mistakes other people missed. If anyone should be able to handle a bank form, it is Curtis. And yet Curtis got completely blindsided, not because he was careless, but because retirement rules are built out of tiny details that even brilliant people never think to look for. His story shows you that being smart is not enough. You have to know exactly where the traps are hidden. And our third friend is Lorraine. She is 72, a former small business owner from Georgia who ran a beloved neighborhood bakery for almost 30 years before she sold it and retired comfortably. Lorraine has money in the bank, a paid-off home, and a lifetime of running her own affairs. She is the type who says, "I have been handling money since before you were born. I think I know what I am doing." And that confidence, that very understandable confidence, is exactly what nearly cost her everything. Keep Lorraine in mind, because her mistake is the one that catches the people who feel the safest. So let us start with the heart of all this. When you walk into a bank and add someone to your account, most people assume they are just giving that person permission to help. Permission to write a check when your hands are shaking, permission to grab some cash if you are in the hospital, permission to keep the lights on if something happens to you. That sounds harmless. But here's the part very few retirees ever hear about. When you add someone as a joint owner, you are not giving them permission. You are giving them ownership. Full, equal, legal ownership. From that moment on, every dollar in that account belongs to them just as much as it belongs to you. And that one word, ownership, is where the trouble begins. Which brings us right back to Rosemary. After her husband passed, Rosemary wanted to make sure that if she ever got sick, her son could pay her bills without a lot of paperwork. So she walked into her bank, and the teller, trying to be helpful, said, "The easiest thing is to just add him as a joint owner." Rosemary signed. She felt relieved. For 2 years, nothing happened, and she forgot all about it. Then her son, who owned a small landscaping business, hit a rough patch. A customer sued him over a contract dispute, and the court entered a judgment against him. And because Rosemary's son was a legal co-owner of her account, her money, the money she had saved for 30 years, was suddenly fair game to his creditors. She had done nothing wrong. She had simply attached her life savings to someone else's risk. Now here is where things become even more interesting and a little bit frightening. Rosemary always believed that because it was her Social Security check being deposited and her money, the courts would surely protect her. But that is not how joint accounts work. Once money is mixed together in a jointly owned account, the law generally treats all of it as belonging to both people. Her son's creditor did not have to prove which dollars were his. They could go after the whole balance. Rosemary told me later that the night she got the notice, she sat at her kitchen table and could not stop shaking because for the first time she understood that her carefulness had never protected her at all. So what should Rosemary have done instead? This is the part where I want you to lean in because the solution is not complicated, it is just something the bank rarely explains. If your only goal is to let someone help you manage your money, you have far safer options than joint ownership. The first is what is often called an authorized signer or convenience signer. That person can write checks and handle transactions to help you, but they do not own the money, their creditors cannot touch it, and it does not become theirs when you pass away. The second option for handling things if you become unable to is a properly written financial power of attorney, a legal document that lets someone act on your behalf without ever making them a co-owner of a single dollar. Same help, none of the danger. And if your goal is simply to make sure the money passes smoothly to your loved ones after you are gone, there is a beautiful little tool called a payable on death designation, sometimes shown on forms as a beneficiary or a transfer on death account. You stay the sole owner while you are alive. Nobody else can touch it. But the moment you pass, the money goes directly to the person you named, quickly, privately, and without the long court process called probate. Rosemary eventually removed her son as a joint owner and set up a payable on death designation instead. Her son can still inherit everything, but now his business troubles can never again reach into his mother's savings. She told me she finally sleeps through the night. Now pay close attention because this next mistake catches even experienced retirees, and it is the reason I wanted you to meet Curtis. Curtis, our sharp retired engineer from Arizona, fell in love again. A few years after his divorce, he met a wonderful woman, and after dating for about a year, she moved in. Curtis wanted to show her that he trusted her, that this was serious. So he added her name to his primary checking account, the one where his pension and his Social Security landed every month. To Curtis, it was a gesture of love and partnership. He did not think of it as a financial or legal decision at all, and that right there is the exact blind spot. Here is the trap that Curtis, for all his intelligence, never saw. The person you add to your account does not have to do anything wrong for it to hurt you. Remember, a joint owner has full access to every dollar. They can withdraw all of it at any time, without your permission and without telling you. There is no rule that says they can only take half. There is no requirement that they ask first. Curtis assumed that because they were partners, any withdrawal would be a shared decision. But the bank does not care about your relationship. The bank only cares whose name is on the account, and both of their names were on it. Curtis had handed another adult a key to his entire retirement, trusting that she would never use it in a way that hurt him. Now, I want to be fair because this next part surprised even me. In Curtis's case, his partner never stole a dime. She was a good person. But something else went wrong, something almost nobody thinks about. She had significant credit card debt from before they met, and when a creditor came after her, they discovered she was now a co-owner of an account with a healthy balance. Curtis suddenly found his own retirement money frozen and tangled up in a debt that was never his. He spent months and a good deal of money on lawyers just to untangle what one signature had knotted together. This next point surprises almost everyone, so let me say it plainly. When you add someone to your account, you are not just trusting that person. You are trusting everyone they owe money to, everyone who might ever sue them, and even someday a divorce court. Let me sit on that word divorce for a moment, because it matters more than people realize. If you add an adult child or a new partner to your account, and that person later goes through a divorce, the money in your account can be pulled into the fight as a marital asset. Imagine that. You could end up watching a portion of your own life savings be handed to your child's former spouse, or your partner's former spouse, someone you may barely know, all because two names shared one account. This is not a rare horror story. It happens quietly every single year, and the retiree almost never sees it coming until the moment it lands. So what was the right move for Curtis? Love and money can absolutely coexist, but they need a little wall between them. If Curtis wanted his partner to be able to help with shared expenses, the smart approach would have been to open a separate joint account, just for household bills, funded with a set amount each month, while keeping his pension and Social Security in an account that was his alone. That way, if anything went wrong, the only money at risk was the small shared amount, not his entire retirement. And what happened next completely changed how Curtis approached the problem. Once he understood the danger, he restructured everything. He kept the love and he kept his security, and he told me he wished someone had explained this to him before he ever walked into that bank because he would have done it right the first time. Now, here's the part I really want you to hear because it leads us to Lorraine, and Lorraine's story is the one that keeps me up at night. Lorraine, our confident former bakery owner from Georgia, is exactly the kind of person who thinks none of this applies to her. As she got a little older, she hired a lovely woman to help around the house a few days a week, running errands, driving her to appointments, picking up groceries. Over time, Lorraine came to depend on her, even to consider her a friend. And to make the errands easier so this helper could buy groceries and pay small bills, Lorraine added her to her checking account as a joint owner. In Lorraine's mind, it was just practical. She trusted her judgment. She always had. This is the mistake that experience and past success do not protect you from, and here is why. Lorraine had run a business for 30 years, so she believed she could read people and manage money in her sleep. But being good at running a bakery is not the same as understanding banking law, and confidence has a way of skipping right over the fine print. For several months, everything was fine. The helper bought groceries, paid the small bills, and Lorraine did not look too closely at the statements, because why would she? She trusted her. And that gap, the space between trust and attention, is exactly where the danger grows. Then one afternoon, Lorraine's niece was visiting and happened to glance at a bank statement on the counter. She noticed several withdrawals that did not match any groceries or bills, small at first, then larger. When they added it all up, the helper had quietly taken more than $11,000 over a few months, a little at a time, counting on the fact that Lorraine was not watching. And because Lorraine had made her a legal joint owner, technically, in the eyes of the bank, the helper had every right to that money. She was an owner. She had not broken into anything. She had simply used the access Lorraine handed her. Recovering that money became a painful uphill fight, and much of it was simply gone. Now, here is the part that makes Lorraine's story so important, and I want you to really let this land because it could save you a significant amount of money. If Lorraine had lost her mental sharpness a little further, if she had fully depended on that helper without a single family member checking in, that $11,000 could have become 50,000 or 100,000 or everything. This is one of the most common ways older Americans quietly lose their savings, and it almost never looks like a dramatic crime. It looks like a helpful person, a trusting senior, and one signature on a form that gave away far more than anyone intended. So what should Lorraine have done? The exact same principle we keep coming back to. If someone needs to buy groceries or run errands for you, you do not make them a co-owner of your life savings. You can set up a separate small account with a limited amount of money for errands, so that even in the worst case, the loss is capped at a small sum. Or you can use a properly documented power of attorney with real oversight, ideally with a trusted family member reviewing the statements regularly. Lorraine, to her credit, learned fast once the truth came out. She closed the joint account, opened a small errand account with a strict limit, and asked her niece to look over the statements every month. Her exact words to me were, "I spent 30 years watching every penny in my shop, and I still got caught, so please tell people not to let their guard down just because they think they are too smart for this." Let me pull these three stories together because there is a thread running through all of them that I do not want you to miss. Rosemary added her son and nearly lost everything to his lawsuit. Curtis added his partner and got tangled in her old debts. Lorraine added her helper and watched thousands quietly disappear. Three very different people, three very different reasons, and yet the same single mistake at the center of all of it. They confused giving help with giving ownership. And the banks rarely stop to explain the difference because a joint account is the fastest form to fill out and the easiest thing for a busy teller to suggest. So let me be very clear about the three kinds of people you should think long and hard about before ever adding to your bank account. And remember, this is not about love or trust. It is about protection. First, be extremely cautious about adding an adult child, no matter how responsible they are, because their lawsuits, their debts, and their divorces can all reach your money the moment their name joins yours. Second, be careful about adding a new spouse or romantic partner, especially early on, because their financial past becomes your financial risk overnight. And third, never add a caregiver, a helper, or a friend as a joint owner, because that arrangement creates the easiest opportunity for loss that exists in all of retirement, and it happens more often than anyone likes to admit. Now, I know what some of you are thinking because I hear it all the time, but I need someone to be able to help me, especially if I get sick. And you are absolutely right to plan for that. The good news is that everything you actually want to accomplish can be done safely without ever making someone a co-owner. If you want help managing money now, use an authorized or convenience signer or a power of attorney. If you want your money to pass smoothly to a loved one when you are gone, use a payable on death or transfer on death designation, which skips the long court process entirely and keeps you in full control while you are alive. Every goal has a safe path. The joint account is almost never that path. And here is one more piece that very few people ever consider, so let me give it to you as a small gift. When you add an adult child as a joint owner to an account or to a home, you can accidentally create a tax headache for them later because you may strip away something called a stepped-up basis, which can mean a larger tax bill when they eventually sell or inherit. I will not drown you in the details here, but I want you to know it exists because it is one more reason that the simple-looking joint account can cost your family real money down the road. If this applies to you, that is a perfect question for a qualified advisor, and it is worth every minute of the conversation. If you take just one thing away today, let it be this. The name on your bank account is not a small detail, and it is not just paperwork. It is a legal decision that can either protect everything you built or quietly put it all at risk. Rosemary, Curtis, and Lorraine were not foolish people. They were careful, they were smart, and they were experienced. And every single one of them nearly paid a heavy price for a mistake that took 30 seconds to make and months to undo. The difference between them and the countless people who lose everything is simply that they found out in time. And now, so have you. So take a look at your own accounts this week. Ask yourself whose name is on them and why. If you added someone as a joint owner just to be helpful, call your bank, ask about convenience signers, payable on death designations, and powers of attorney, and fix it before life ever gets the chance to test it. It might be the most important phone call you make all year, and it costs you nothing but a little time. If this opened your eyes even a little, do me a favor and subscribe, because I put out these updates to help you stay one step ahead of the rules that nobody bothers to explain. Share this video with a friend, a brother, a sister, or a neighbor who might have a name on their account they never thought twice about because you could genuinely save them from a heartbreaking loss. And I would love to hear from you in the comments. Which of these three mistakes surprised you the most? Or have you seen something like this happen to someone you love? Your story might be the very thing that protects someone else who reads it. Please remember this video is for educational purposes only. For your personal situation, always consult a licensed financial advisor or contact Social Security directly at ssa.gov.